I am honored to stand with you tonight. So let me talk to you for a few minutes about your case. We filed our case, and I love your case. I think your case is a great case. So Theodore Roosevelt Park was dedicated in the 19th century. In 1876, the state legislature decided to make a portion of the park available to this great, wonderful, special, amazing museum that they were going to come up with. And in that dedication, they authorized the city of New York, the legislature authorized the city of New York to enter into a lease with the museum, and the city was authorized to build multiple buildings. However, when the city chose to enter into that lease, do you know how many buildings they authorized the museum to build? One. Now, in our case, the museum is arguing that at that time, at that dedication, the entire park was dedicated for use by the museum. And they didn't need any other further authorizations, they didn't need any more leases, they didn't need more permissions, licenses, permits, they got it all like that. Except that after that dedication, there were three or four pieces of legislation in which they were given additional authorization. So if they got it all the first time, why did they need the additional authorizations? And here's something fascinating about that. When they got the lease, okay, they were leased a portion of the park, and they were leased not only that portion to occupy, but they were given something called appurtenances. Now, appurtenances has a meaning today, but for purposes of this lawsuit, for purposes of understanding the lease, it really doesn't make a difference what appurtenances means today. It means, what's relevant is what it meant back on the day the contract was signed. So what did appurtenances mean back then? Well, appurtenances were pieces of property you needed to access in order to get to your own property. So for a moment, I'm going to just be a little visual here. So I'm going to hold this here. Everyone's watching. I'm putting it on the table. Let's imagine the whole table is the park, and this is the museum. An appurtenance would be, if they have the right to occupy this spot right here, but that's all they have the right to occupy, they'd have to pole vault into the museum to get there. So in the 19th century, they gave them what are called appurtenances. So I'm going to use this. This is completely unplanned, by the way. And this would be a walkway across the park. Now, the park is owned by the city, and the museum only got this one part here to occupy. So the lease says you get appurtenances also. And appurtenances are a right, in the 19th century, a right to use an access route. That's what it means. Now, ask yourselves a question. If they got the whole park, right, and they could use all the spaces in the park, why did they have to get special permission to get this access route? They already owned it, if they are right. So clearly, they weren't given the whole park. And that is the basis for their whole claim. We can build whatever we want. We don't give a damn about the community. But they can't, because the law is what the law is. They only got the space they occupied. And when they got additional dedications, they got additional space. But they didn't get the whole park. God forbid they should get the whole park. They didn't get the whole park. So, what does that mean for you? Well, under New York law, if you get additional land from the city, if you are, for example, let's say they got this land, they get some more land, which is what they're taking now, they can't just get it. The city can't just give it to them. What the city must do is the city must go through a process called the ULURP process. To me, a ULURP process sounds like a noise that a baby might make while they're drinking their milk. But a ULURP process is a Uniform Land Use Review Procedure. And that is a multi-phase, multi-step, multi-agency, multidisciplinary process by which the city must evaluate all of the impacts that this plan might have. And it's designed to ensure that land isn't just given away to other people or other organizations or other institutions. Now, Bill said that the museum is not a good neighbor. I would agree with that. I would say that institutions generally, as much as we may enjoy them, like for example the Metropolitan Museum of Art, I love the Metropolitan Museum of Art. It's beautiful in there. It's amazing. But they are an institution, just like NYU is an institution, and Columbia is an institution. And for those of you who know what's going on in downtown Manhattan or in Morningside Heights, you know that universities are expanding like locusts. They cover everything. Well, the museum is really no different, and if you're not careful, they are going to get the whole park. So this is the time for us to stand up and make sure that everybody knows that the museum gets what they've gotten. And if they want more, they have to go through the review process, which requires the participation of your elected officials who have to answer to you. That's right, us. I shouldn't say you because I'm part of you. Us. They have to answer to us. And when they violated that requirement, that they go through the ULURP process, they violated the law. And when that happened, that gave us a right to bring the claims that we brought, and that is the first claim that we have in the case. And I love that claim. In addition, one of the most disturbing parts of this plan they have is contained in all these volumes here. It's scary what they've got going on. I wrote some of them down. Excuse me. So first of all, there are the noise impacts, and that, that's not great, right? And the noise impacts are greater than what's permitted under the building code. But that's just the beginning. Something called TCE, trichloroethylene, is in the ground. Now, has anyone seen the movie Erin Brockovich? I love that movie, right? Erin Brockovich, great film. So, in that film, for those of you who don't know, and I'm not ruining it for you because it's a true story, so you should all know it, okay? Erin Brockovich is a story about a paralegal who gets involved in an investigation concerning contaminated groundwater, which ultimately leads to the deaths and serious illnesses of people throughout a community in Texas, I believe it is. And she investigated trichloroethylene, she consulted experts, and she found out that stuff makes you sick and can kill you. Trichloroethylene is in the park. TCE, according to these studies, is in the park, your park. And if you, now don't get me wrong, if it's not disturbed, you're fine. But if it is disturbed, then we have real problems. And that's just the beginning. They have underground storage tanks, they have asbestos, lead, volatile organic compounds. The park itself, again, if undisturbed, will not create problems for you. But once they start digging in, that creates enormous risk. And think about what is in proximity to this park and in proximity to these chemicals. There's a school across the street, there's the farmer's market. There are people who use that park every day, walking back and forth with their kids and their dogs, and families. All of that places all of you at risk. You're all at risk. And it's not just that. There's also the transportation and traffic impacts. Now, by their study, the increase in population density for purposes of the entryway to the museum is about 900,000 people a year. But that is an extrapolation based solely upon how many people visit the museum now, and based upon the increase in square footage, how many additional people would go. If you assume for every additional square foot, there's an additional number of people who come to the museum. To me, that's a little bit bizarre. But I think the larger point is, and the one that they don't consider, is that, as Bill pointed out, they plan to make this a major entry point to the museum, and they plan on improving the facilities in the back of the museum. Now, if they improve the facilities to the back of the museum and they make it more attractive, it's going to be more than just a proportional square footage increase in population. There are going to be many more people traveling and using this route. Anybody who's coming from the west side of Manhattan, for example, is going to use the access in the back now, especially if it's providing such a great entryway to the museum. They didn't consider any of these facts. They simply did a square footage analysis based upon how many more people go to a museum if you increase its size. And that's simply not an appropriate way to calculate the potential increases in population density. And then we can talk about traffic and transportation impacts. A lot of people go to the museum. You know how they get there? Some of them take the subway. A lot of them do. A lot of people drive. What's going to happen with those cars when people start double parking cars? What about the schools with the school buses idling there on the streets because they're going to use a new entryway to the museum, to the Gilder Center? And what happens and for those of you who take cabs or drive in Manhattan, and if you do that, you have my sympathies, although I drive also. What happens when you have a double parked car on any thoroughfare in New York City? Traffic stops, honking starts, idling cars in traffic create an increase in our collective carbon footprint. So we're talking about traffic and honking and noise, but we're also talking about ambient air quality. And what's that going to mean to you guys? There are really serious problems with this. The loss of the farmer's market, the loss of your park for the period of time the work is being done. These are impacts that they did not adequately consider. So in addition to the claims we have under ULURP, which is their failure to get permission to get additional land, right, because they're taking additional land for the Gilder Center. In addition to that, there are significant environmental impacts, and our position is they have violated the State Environmental Quality Review Act and the City Environmental Quality Review. Good insight. My grandmother would say she sneezed on it, which is a good thing. Anyway, so those are the claims that we have in the suit right now. We have received the administrative record, which if I stood on it would make me taller than Bill, so it's a big pile of paper. And then following that, we put in our papers. We're going to amend our petition to strengthen what we have based upon the new information that we just received. In addition to that, we're going to be submitting a brief. And then we're off to the races. The other side's going to put their papers in, and then we're going to go to court. The judge that we have gotten in this case is the same judge who handled our case against the clock tower at 346 Broadway, which we won. And I must tell you, and I'm not just saying this because we won, but she really is a terrific judge. And I'm excited about the prospect of arguing this case in front of her because she does take the time to really study the issues. There are judges in New York who, when they see an Article 78, which is what our case is technically called, an Article 78 case, they think to themselves, well, Article 78 cases are so hard to win. Very, very often judges will immediately assume that the petitioners in that case don't have a very good chance. Justice Kotler, who's our judge, is not one of those judges. She cares and she considers. And that's really the best you can do. If we are entitled to win this case, I'm reasonably confident that Justice Kotler will find for us. And I do believe we're entitled to win this case. So that's kind of an update of where we are and where we're going. As for you, what I would ask of all of you today, all of you, is two things. Number one, I ask you all to keep your eyes on the prize. You got to take a look at the Teddy Roosevelt Park. Make sure you look at it every day. And you may say, why do I have to look at the museum every day? Because I need to know if work is going on. The minute they start doing work, we have no choice. We got to go in there and get a temporary restraining order and preliminary injunction. So as soon as you see someone doing something, you know that saying, see something, say something? Contact your leadership. They're fantastic. They get back to us right away. So if you hear anything about what's going on, please speak to Bill, Claudia, or Laura and tell them what's going on. They will be in touch with us immediately. The second thing I could ask of you is that at some point in time, we're going to have oral argument before our judge. The room is relatively small, but I think it's still important for everyone to come. When I say everyone, I mean all of you and anyone else you know who cares about this issue. That's so important because if the judge thinks this is just one or two disgruntled, people who are rabble-rousers, for those of you who read the New York Daily News editorial today, you know what I'm talking about. There are movements within the city of New York that like to try and marginalize people who preserve. Whoever got to the editorial staff at New York Daily News clearly is one of those people. But I can promise you this, it is an important issue when you're talking about going to court. Not to say that the judges are going to say, well, there are a lot of people here, so I'm going to rule for the plaintiffs. That's not the way it works. But by the same token, I think it's very important for all of you to remember that this is a community action. It is not just Bill or Laura or Claudia or any individual person. This is on behalf of all of us. So it is important for the courts, for the media, for our opposition, for everyone to know. And if there is a member of the opposition here today, sort of like trying to get intelligence, we're coming. We're all coming to court because we're not backing down. The worst thing that we can do in a land use and zoning fight and a preservation fight is to back down. Don't back down. Stand up and fight. We stand up and fight, we win this thing.